Okay, so good morning, everybody, both those who are live in the Senatskammer and also those who are online. Welcome to a workshop, a joint workshop between two projects, the TRICI-Law project and the EU Diplo project on EU and the interpretation of customary international law. A few words, very, very few words, because nobody really cares about what the organizers have to say. Everybody's more interested about what our stellar lineup of speakers have to say. As I said, this is a joint workshop between TRICI-Law and EU Diplo. So TRICI-Law is a project, a 5-year project funded by the ERC, the European Research Council, and it stands for the rules of interpretation of customary international law. Because what we observed was that although state practice and opinio juris is essentially the dominant way of looking at customary international law, that this reflects the identification whether the rule exists. But what we saw from practice, not only of international courts and tribunals, but states as well, so domestic courts, but even statements by state officials, that they were using methods that were very close to our understanding of interpretation. So using other methods aside from looking at state practice and opinio juris to further refine the content. And then on the other hand, the EU Diplo project, which in and of itself is a Jean Monnet network project between the universities of Geneva, led by Professor Cadus, the University of Groningen with our co-organizer, our vice dean, Professor Ramses Wessel, the University of Leuven by Professor Wouters, and the University of Pisa by Professor Pol. It is essentially a project, a network, which focuses on the central questions between the internal and external constraints, but also opportunities of the European Union as an international diplomatic actor. So this workshop essentially came out of Professor Wessel and I meeting at another workshop, locking our eyes, raising our eyebrows and saying, maybe there is something here that we can explore. So this is essentially a byproduct of this engagement, and we're really excited to see what will come out of this, because we do feel that the EU has something really interesting to contribute to both our projects, and that's why the structure of the project today has also this internal, external kind of construct. So how customary international law affects the EU, and essentially also how EU internalizes customary international law. Whether indeed there is a tendency of what they said, Volksrechtsfreundlichkeit, so a friendly attitude or a friendliness to public international law, or not, depending on your views, but also the external aspect on how essentially the EU in and of itself engages with interpretation, how it affects our understanding of customary international law, and potentially even go as far as modifying, so changing the rules of customary international law. So that, in very, very, very rough broad strokes, is the theme of today's workshop. Again, I would like to thank our speakers, a wonderful lineup of speakers for coming from all over the world. Although we should have insisted that you wear green to continue our celebration. Not green, orange, sorry. Green, I went with my team in Greece, Panathinaikos, but that's a different story. So orange for King's Day, but we decided that may have put too much toll on the wardrobe requirements of our speakers. So without any further ado, thank you very much to our speakers, and we're very much looking forward to everything that you have to present. And I will pass the floor to Ms. Marina Fortuna, who will chair and will introduce our speakers. So thank you very much.
Good morning. My name is Marina Fortuna, and I'm a PhD researcher in the TRICI-Law project, and I have the pleasure today to chair this wonderful panel. I was told that the timing will be enforced very strictly, that I should do that. So to this end, I have some tools here. I hope there will be no need to resort to them. So I kindly ask the speakers to please give a presentation in around 15 to 20 minutes. So we will we'll move from presentation to presentation and then have a discussion with the audience. Yeah? Okay, so I would like to now introduce our first speaker, Fernando Lusa Bordin. Dr. Bordin is an assistant professor of international law at the University of Cambridge and John Thornley Fellow in Law at Sidney, Sussex College. His research focuses on topics of public international law, including international legal theory, lawmaking, the law of international organizations, international dispute settlement, the law on the use of force, and international investment law. His monograph, The Analogy Between States and International Organizations, was published by Cambridge University Press and received the 2020 Certificate of Merit from the American Society of International Law. And his monograph investigates how the analogy between states and international organizations has influenced and supported the development of the law that applies to governmental institutions on the international plane. Because all our speakers have so many publications, I had to select a highlight. So by no means this is the only publication. And now I give the floor to Dr. Bordin, please.
Thank you very much. Thank you, Professor Vessel. Thank you, Professor Mercouris, for this invitation. I am very excited to be at this workshop in this beautiful building, and I come here as an envoy of sorts, I suppose, from a Kindred research project. And that was a project on the European Union and custom that I led alongside my colleagues Andreas Müller, who is now at the University of Basel, and Francisco Pascual Vives, who is at the University of Alcalá in Spain. And the project culminated in the publication of an edited volume, called the European Union and Customary International Law by Cambridge University Press last year. And in the spirit of linking the two projects, I just wanted to take the opportunity today to share a few reflections borne out by the book on why the EU, as Professor Mercouris has just suggested, is an excellent case study when it comes to matters pertaining to the identification, interpretation, and application of custom. Now, that is a point on which Jan Klabbers and I have been having a long-standing conversation over the years. Jan, who you will know is a leading, perhaps the leading scholar in international organizations law of our times, he tends to think that the EU is a little bit too advanced, a little bit too different, a little bit too specific to provide a central case study from which we can derive conclusions for other international organizations and international law at large. But I happen to think otherwise. And I'm bringing in this little handout that has been shared with you a little quote from my own chapter in this edited volume, which encapsulates my basic intuition. And that is the intuition that the EU can be described as a trailblazer. It has shown that there are few competencies that states cannot transfer to international organizations if they so wish, even on an exclusive basis. And it has likewise shown that there are few rules of custom that cannot be relevant one way or another to the functioning of international organizations, casting doubt on arguments that international organizations are somehow removed from the purview of CIL. Now, I am of course not suggesting that the EU is representative of international organizations. It is not. It is quite advanced in ways that other international organizations are not. But I do think that the EU provides a blueprint for how far international organizations can go when states become very serious about taking collective action. It basically provides a test case of how this legal form, this legal construct of international organization can be deployed not only for cooperation, integration, looking inwards, but also for external action, ways of dealing with the outside world. And I would like to unpack this intuition by making 3 points. The first is that the EU is a great case for the study of custom because it is a regional international organization. And I should give a shout out here to Eva, who is sitting over there, who is one of the chairs of a project by the International Law Association that is looking at the law of regional international organizations, trying to really parse out the role that those organizations play in building and applying international law. And why do I highlight what is a very obvious characteristic of the EU? That is because when we ponder international lawmaking, we normally turn to universal international organizations, especially the UN. And of course, when we think about the importance of, say, General Assembly resolutions or ICJ judgments or ILC codifications for the identification, interpretation, and application of custom, we cannot really overstate their importance. They are central materials for all of that. But universal international organizations, they have relatively limited opportunity to maintain the kind of external relations for which custom becomes crucial. Whereas regional organizations, such as the EU, they have a much wider world, much wider external world, let's put it this way, to relate with. And therefore, looking at what those organizations are doing becomes particularly interesting. And also, when universal organizations are contributing to the customary process, either by serving as focal points for the practice of states or through the conduct of its own organs, those organizations will, at least to an extent, be representative of the international community at large. And they will be, at least to an extent, accountable to the international community at large. In contrast, the position of regional organizations like the EU raises some far more pressing legitimacy concerns, because the EU may well be a cosmopolitan organization, even a globalist organization, as some critics would like to point out. But it is ultimately representative and accountable to the 27 European states that have set it up. So here we have an example of how states can pool their resources and affect the customary process by acting through a much more powerful entity, an international organization, but do so with distinct regional partisan sensibilities, not with some sort of universalist outlook that would be catering to the international community as a whole. Now, the second reason why I think the EU should be a central case study for custom is that it is not only a regional international organization, but also a regional organization with very broad and very consequential competencies to take action on the international plane. And in that regard, it is quite unique, at least in the current stage of the development of international practice. So the fact that it exercises jurisdiction over so much human activity taking place abroad, the fact that it engages in so many diplomatic exchanges, international negotiations, international processes, that it concludes so many treaties, including treaties that are typically open only to states, the fact that it gets even involved in military operation, including enforcement action on the abroad, that all makes custom especially relevant for the international relations of the EU and makes it possible for the EU to play a distinctly influential role in shaping customary rules. And then the third reason why I believe the EU is and should be a fascinating case study for custom is its unparalleled degree of centralization. The fact here that the EU has a robust, structured, and sophisticated legal system that is overseen by a fully fledged judiciary, and a legal system that not only member states have access to, but individuals have access as well. And I believe that this degree of centralization that the EU boasts, it means at least three things. The first is that the EU gets to make a distinct contribution to custom through its own practice, as opposed to just serving as a forum for the practice of European states. Not least through the case law of the Court of Justice, and that is a point that Jed Odermatt here has made in his own work very persuasively, and you have a little quote from his chapter in the edited volume in the handout to take a look at. Now, the second thing that the centralization of the EU means is that that kind of centralization leads the EU to perceive itself as unique, as sui generis, and that creates an incentive to ask for preferential treatment under customary international law. Bespoke rules that will cater to the structure of the EU. And that can be certainly a catalyst, a vector for legal innovation, for really pushing the system forwards. But it also raises a few concerns, legitimacy and otherwise. And I suspect that we will hear more about this from Teresa a little bit later today. Now, the third thing that EU centralization means is that the EU ends up providing, as Professor Mercouris has said before, what is the richest case study we have for the identification, interpretation, and application of custom within the internal legal order of an international organization. Now, formally speaking, the internal law of every international organization forms its own partial legal order under the total legal order of public international law. And I'm using some Clausenian terminology. He uses the phrases total legal order and partial legal order when he looks at juristic persons, moral persons, and how the statutes of, say, a corporation will relate to the legal order of a state. And the extent to which that partial legal order can be autonomous from the total legal order is quite great in the case of international law, because international law is very permissive. It allows international organizations to be set up however states want, with the only outer limits being placed, in theory, by the rules of jus cogens, and those are far and few. So in the first instance, the partial legal order of an international organization can be as open or as closed as the member states and the organs of the organization later in the process are willing to make them. And it so happens that EU law is all too happy to take the autonomy that international law allows it to have very, very far. The Court of Justice has articulated, as everybody will be aware of, a doctrine of autonomy of the EU legal order, which was originally meant to safeguard EU law from the domestic law of the member states, but has later been extended and applied towards international law. At the same time, we are all aware that there is a self-perception within the EU that the organization is open to international law, it is friendly to the international legal order. And we get that from the case law of the Court of Justice. The well-known Hague case is a good example, confirming the understanding that custom binds the European Union and is also a yardstick against which secondary EU law can be reviewed. But that position of principle, I don't think it's always reflected in practice. And Paul Gragel has a chapter in the collected volume here where he takes a good, deep look at how the Court of Justice has been applying substantive rules of custom, rules of jurisdiction, rules coming from the law of treaties, the principle of self-determination. And he comes to the conclusion, a bit provokingly, that the Court of Justice basically instrumentalizes customary international law, that it is all too happy to refer to custom in support of conclusions that it would have come to anyway, sort of custom. The customary argument becomes a low-hanging fruit that the court is just very happy to pick, but does not really go very much further than that. And he says, and you have a quote in the handout, that there is one concept that overrides all other considerations, the union's legal autonomy. As long as custom can be used in the interests of EU law, this is not a problem. But once it potentially becomes a threat to it, any further invocation or application of substantive rules ends. At the same time, the court has so far never resorted to a reasoning that became directly threatening to custom. In this context, one could argue that it is a common phenomenon that domestic courts interpret international law in a different way than international courts and tribunals. And that is why the Court of Justice has become a domestic court that protects the constitutional legal order of the domestic system it resides in. Now, something that the Kari saga has made very clear is that the Court of Justice can indeed behave as a domestic court sometimes, and even a relatively parochial domestic court at that. So the potential for customary international law to shape EU law for example, through the doctrine of direct effect, remains a bit theoretical. And two contributions in the book, the ones by Werner Schröder and the one by Andreas Müller, they try to think of better ways in which the Court of Justice could approach the applicability of custom in cases concerning individuals. But I think the passage that I really wanted to bring to your attention to wrap up my contribution comes from Kirsten Schmalenbach, who is somebody who is a teacher of European law, but is, we could say, somebody who focuses on public international law a lot and gets the perspective of public international law very clearly. On a chapter in which she's looking at this twilight between international law and EU law, she suggests that it can be said that the EU has not completely severed the tie between international law and EU law to its point of origin in public international law. However, the situation continues to evolve, and the determination of the degree of self-containment rests largely in the hands of the Court of Justice. And what I find striking about this passage is that it implies the possibility that the EU could completely sever the tie that it has to its point of origin in public international law. Now, is that a matter, as a matter of principle, is that a possibility really? Is this something that we can legally justify or explain? To me, this comes across as almost a Freudian slip of some sort, and it reminds me of a fascinating exchange that we had in the workshop that led to this project, which maybe Jed will recall. I was just making what I thought was a basic point, not very controversial and very tame, that ultimately EU law will derive its validity from public international law, even though that doesn't really mean much, because again, international law allows for almost full autonomy for EU law, and then we would have to kind of imagine some sort of outlandish scenario in which EU law is conflicting with jus cogens to have international law really forces itself in. But a colleague in the room called me out. He said, it would be hard to imagine the Court of Justice ever applying jus cogens to invalidate a rule of primary EU law, for example. And whatever the court decides will be what the law will be, and that will be what the position will be, and then autonomy will be safeguarded. And the quotes that we get from Schmalenbach and that exchange, in a way, they show that centralization can be such that it can present an institutional reality capable of subverting core systematic assumptions that come from public international law. That the identification, interpretation, and application of custom within international organizations that make themselves very autonomous, it may come up to look very differently from what public international lawyers might have dreamed of when they thought, international organizations, of course, are creatures of international law, and they will have a completely different relationship with international law than what we see domestic lawyers doing. So to wrap up, the project I have been involved with shows that the EU is a fascinating case study for custom because it is a regional organization, a powerful and active regional organization on the international plane, and one which displays this uncommon degree of centralization. And those features, I'm sure, will color your appreciation and my own appreciation of how custom gets interpreted by and within the EU, and I'm sure we'll hear more about that today. Thank you so much again.
Thank you very much for this very interesting presentation. I already have some questions.
That's good.
Yeah.
I'm glad.
Okay, for now we move on to our second speaker. Dr. Jed Odermatt. Dr. Odermatt is a senior lecturer at the CJEU School at the University of London, City University of London, where he is a co-convener of the International Law and Affairs Group and member of the Institute for the Study of European Law. His research and his publications relate to public international law, international dispute settlement, the law of international organizations, and EU external relations. He is also the author of International Law and the European Union, a book that came out in Cambridge University Press in 2021, which analyzes the impact that the European Union has had on public international law. Dr. Odermatt, you have the floor.
Thank you. Thank you for the organisers for inviting me. It's great to be in Groningen, especially when I arrived yesterday with all the orange and everything everywhere and people drinking beers on the train. And if you were to maybe have one day in the Netherlands and you just happen to arrive in King's Day and leave, you might get the impression that in Netherlands every day people dress up in orange and drink beer and that's what it's like. Similarly, if you focus on some of the big name cases, the ones that we often write about in this field, and I'll refer to some of them, you might also get the impression of things like friendliness or engagement with international law and customary international law. And what we've tried to do in this project or this paper is to not just focus on some of the landmark or big name cases, but to look more generally at all of the references to customary international law that the court has taken. And this is to help examine this question of interpretation. That is, time and time again, I see, and I've written about this topic as well, this story of the Court of Justice applying and interpreting customary international law through the lens of EU law. Or sometimes the metaphor that's used is that it puts a EU law twist on customary international law or an EU law flavour. And we want to kind of understand, what does that mean to apply international law, not as if you are the Court of Justice of the International Court of Justice, but as a court of a regional organisation or even a domestic court. And went back and found what we think is the first reference to customary international law in a case that maybe not the one that is always discussed in textbooks and so on, a competition law case against where a firm based in Switzerland was challenging proceedings against it, saying that we're based in Switzerland, we may be active on the European market, but by bringing a case against us, the Commission is violating or misinterpreting the effects doctrine in international law. And it referred to the effects doctrine and said, well, look at state practice and the objections in state practice. Look at different cases from around the world, the ICJ, what the Lotus decision says, or what the US said. So it had, at least in the arguments of the parties, quite a lot of engagement and discussion on public international law ground. Whereas when it came to actually mention customary international law in the decisive part, the operative part, you can see that there's this very brief, almost blunt reply saying, well, international law cannot be invoked to deny the community to take powers to ensure the effectiveness of measures to prevent or to enforce competition law, basically. Okay, that's the extent of the reasoning. I'm not cutting out other parts about customary international law. I'm giving a screenshot of the extent of discussion, which I think can happen when you look at and zoom out away from the cases that I've written on, such as Air Transport Association of America, or RUCCA, which you mentioned, or the Front Polisario cases, and zoom out to some of these other ones, we see a lack of engagement with customary international law arguments, which fits with the arguments that you made and referred to in your book. So we've looked at all the cases where customary international law is addressed, and also the evolution of some of the literature when it comes to the EU Court of Justice and customary international law. And firstly, we had, well, mainly a discussion about under which circumstances is customary international law even relevant? When does it enter the EU legal order? So cases like RUCCA and so on, there was a question of, well, does it form part of international law? This is why we refer to it. It was a big case in the sense that international law, customary international law, could be applied in the EU legal order. So the circumstances, and this parallels a lot of the arguments about the direct effect of treaties as well. And then I think later on, especially with Fernando's project, and also the project that was taking place by the ILC, which dealt with the EU and the formation of customary international law and the identification, and how the Court of Justice may play a role in that. The extent to which it looks at two elements, to which it refers to other courts and tribunals when identifying customary international law, and whether or not the Court of Justice might, under certain conditions, also contribute to the formation of custom. And then I think there's another more recent trend of scholarship which is going into more finer detail to examine cases, to look at things like how has the court in Front Polisario or the Western Sahara cases actually dealt with self-determination? Has it really got the law of the sea right in this area? To really go into more finer detail, to look at how the Court of Justice actually uses, and international lawyers often come to the conclusion, misuses or distorts public international law arguments when coming to its decision. And that's what I see as the more fine-grained discussion on things like, has the court dealt with immunities in the way that fits with other interpretive bodies and tribunals, or principles of self-determination, responsibility, and having a look at those angles. But what we've done is tried to move away from the so-called landmark cases, the ones you see referred to time and time again, just as a kind of different methodology to use. But also it's interesting to see that the court itself is not just the scholarly academic discussion that does this. The court itself, when you look at its own citation practice when dealing with customary international law, also regularly refers to some of those main cases, which probably the people in this room are very familiar with, things like Air Transport Association and Opel Austria, which the court itself refers to. So we did this kind of project to zoom out to look at all of the cases, including from the Court of Justice and the Advocates General, that refer to some customary international law using different terminologies, and then removing any references where it's actually saying custom when it's referring to something else. And we see this more nuanced picture emerge, that we see references, mentioning of customary international law, but then when you get to the part of its reasoning, the operative part, where it's actually coming to a decision, very little engagement. What do I mean by this word engagement that I sometimes use? It means not just saying the principle of self-determination exists in the UN Charter and in this ICJ case, but then to actually look at, well, how has the principle of self-determination been interpreted by other bodies? To kind of look at maybe academic articles, or just going beyond this kind of referring to it and then deciding on EU law ground. And that's the kind of metaphor I use, that the court is somehow taking this international law argumentation, moving it towards EU law argumentation, and then deciding using the familiar decision-making techniques on EU law ground. This is the nice network that Mikhail made, which actually kind of shows the references, the arrows going out, one case referring to another, and it does kind of track with these main cases I mentioned, right? Air Transport Association, Front Polisario, that the court itself does refer to some of these main cases, and the size correlates with the number of citations. We see Raqqa, Western Sahara cases, and these ones come up. And the different colours also show who is referring, whether it's the Advocate General or Court of Justice. Similarly, when we just look at the number of total references, we do see an increase over time. That's to be expected with just the increased output of the Court of Justice. But we see the Advocates General also referring to customary international law, as well as, especially since the mid-2000s, the Court of the General Court. And maybe, this is just a hypothesis, we see a lot of references when it comes to restrictive measures cases where customary international law is sought to challenge those decisions. And then we can also see spikes because of paragraphs. Again, this correlates with the idea of big cases such as Air Transport Association or the Front Polisario cases, where the Advocates General and Court have made a number of references in the paragraphs mentioning customary international law. But then, is this a trend going upwards over time? Well, we see that this hasn't sustained. There was a trend rising. This is a proportion of cases with customary international law being mentioned, but the General Court, not really that significant, having a bit of an upward trend. Okay. well, for the paper, I just took from 2000 till today to look at all of the cases that have mentioned customary international law, and to kind of see that a familiar trend emerges, that the similar sets of issues arise. The parties themselves will bring up things like the principle of self-determination. These were both restrictive measures cases where customary international law was used, brought up, to say, well, the Kurdistan Workers' Party or Liberation Tigers of Tamil Eelam have, under customary international law, the principle of self-determination, a right to fight against a state, that they have a legitimate right to, because they are non-recognized territories, kind of basing arguments on Front Polisario type arguments, to then say, well, these restrictive measures shouldn't apply to us. And the court then, as you could probably imagine, quickly dismissing that, saying, well, we need to be able to keep together the sanctions regime. This would destroy the effectiveness of EU law. The Council has a wide margin of discretion when coming to these decisions. Similarly, when it comes to some recent cases on immunities, where state immunity was discussed by the parties, the court has either not really engaged with that question at all, such as in Yanukovych, or in Marina, where the court did appear to deal with customary international law issues on state immunity. But then when it came to the operative part, to actually answer the question, to show some reasoning, it was mainly based on EU law, in the sense that customary international law, the state of customary international law at the time, cannot undermine a system of remedies in the EU. The Charter requires individuals in the EU to have access to justice under the EU Charter, and applying customary international law could undermine that system of remedies. So again, we see EU law being applied, principle of effectiveness. The court doesn't ever mention autonomy in these, it doesn't explicitly mention autonomy, but you can see that kind of reasoning coming in. Cases coming up addressing the issue of the territorial scope of EU law. Again, often these refer to another case that spiked, this Air Transport Association of America case, where individual parties are saying, well, EU law shouldn't apply outside of the EU territory. Some of the measures in competition law, but also environmental protection and aviation, the EU law may apply to conduct that takes place outside the EU's territory. In these cases, the court mentions customary international law because the parties did, but just basically refers to Air Transport Association of America and says, this is legitimate. It only really refers to its own case law. And we're going to have other presentations which will focus in more detail on some of these cases dealing with the law of treaties. Again, this is another theme that comes up, mentioning the Vienna Convention on the law of treaties, and maybe some of the other presentations will talk about the extent to which it does this in a way that international lawyers recognize as proper and legitimate, but in these cases it's mainly just referring to the VCLT to then use those techniques of interpretation, but not, again, showing much engagement in those cases. And then in the law of the sea, which I think Sea-Watch is a case which goes against that trend, where we have the Court of Justice actually going into quite a lot of detail, being much more bold and maybe even comfortable with the law of the sea arguments and customary international law arguments, maybe because the EU itself is quite active in the area of the law of the sea. It is a party to the UN Convention on the Law of the Sea, but that is one recent case where there was much more engagement in this way. So we see quite a number of references to customary international law, and that trend over time consistently refers to customary international law. Of course, this doesn't cover the instances where customary international law isn't mentioned but may have been brought up by the parties or may have influenced the court. We can't account for that. But we see mostly in those cases I looked into in more detail, the parties have referred to customary international law, and it seems that the court has referred to it only to mention that and then to almost dismiss it, to say the parties brought up this principle of self-determination, but not really engaging with it, or maybe even giving the appearance of engaging with it by mentioning UN charter and treaties and so on, but not really going that step further to discuss how they've been interpreted. Or this technique of bringing in treaties to which the EU is not a party. It's not just the Vienna Convention. We have this with other treaties where maybe the court wanted to apply a certain principle, but it's not part of the EU legal order, so then says, well, because of customary international law, we can use this. Mostly it's been on the Vienna Convention. To go to the issue of the lens, the EU law lens, what is operating in the background? In the operative part of these decisions, I mentioned this idea of moving the argument towards EU law ground. It's really making sure that the EU legal order is effective, to make sure that customary international law doesn't undermine that integrity and effectiveness of the EU legal order. And I mentioned this thing that is unsaid. Maybe it mentions autonomy, principle of autonomy in other cases, but I think this is also something that's there in the background, that customary international law, especially rules to which the EU may not have contributed, cannot then be used to challenge or undermine the effectiveness of EU law. And so this is how I see the interpretation of customary international law through this EU law lens. And you could say, well, is there anything wrong with that? This is not the ICJ. This is a court of a regional organization. It acts much more like a domestic court. And you would expect that it would apply EU law in that way, just as a domestic court would. It has less engagement with the reasoning, international law reasoning and references to other courts. And some of that reasoning is very brief, very blunt, and doesn't engage with public international law. Again, not something that's necessarily a problem. I'm not saying the court has to go in one direction or the other, but this could mean that when it comes to the contribution of the Court of Justice to the development of customary international law, it's probably going to be very little. And this was something the Special Rapporteur on the IOC formation of custom report said, that the role of courts in developing customary international law will also depend on the quality of the reasoning, the level of engagement with international law argumentations and so on. So maybe this EU law lens can mean that the extent to which the court contributes to international law would then be diminished. Yeah, thanks.
Thank you very much. This was a very interesting insight into the practice of the courts of the EU. And now we turn to our last speaker in this panel, Dr. Eva Kassoti. Dr. Kassoti is a senior researcher in international and EU law, as well as the academic coordinator for the Center of the Law of EU External Relations at the Asser Institute. Her research interests include public international law, EU external relations law, as well as the interplay between the international law and the EU legal order. In 2015, she published a monograph entitled The Juridical Nature of Unilateral Acts of States in International Law, where she explored the question of the legal nature of unilateral acts by focusing on their essential characteristics, that of unilateralism, and the manifest intention to be bound. And now I give the floor to Dr. Kassoti.
Thank you very much. I would also like to thank the organizers for this kind invitation. Now, the main aims of the TRICI-Law project are to explore whether customary international law can be interpreted, and secondly, what are the methods and limits of this interpretive exercise. So my contribution focuses on the role of the EU courts in the interpretation of customary international law norms. This examination is important not only because it contributes to the study of interpretation of customary international law, but it also feeds into broader debates pertaining to the use and its courts' interaction with international law. More particularly, this examination has the potential to inform and make more nuanced our framework of understanding and assessing the court's approach to international law more broadly. The relevant debate has been largely conducted through the openness-hostility prism. However, this dichotomy is unable to account for how the CJEU actually uses international law in its practice. If the very terms of the debate only allow us to consider whether the CJEU employed international law norms in the interpretation in its reasoning in order for a given judgment to be considered as open or friendly, then any engagement with international law could be construed as a sign of openness, even if it is simply wrong. In this context, it should be stressed that part of the literature, sitting next to me, has attempted to overcome the openness-hostility dichotomy by focusing on the international domestic role that the court may play in a given case. So according to this line of thought, the CJEU is much more open to international law when it interprets and applies international law to resolve a given dispute, i.e. when it functions in an international court mode. The court is more cautious when it functions as a domestic court, i.e. when international law is used as a yardstick to assess the validity of EU law. I'm not much convinced that this approach makes things clear. First, this argument is premised on the idea that, quote, like domestic courts that apply and interpret customary international law, the CJEU deals with international law in a very specific legal context. In these cases, it is primarily focused on resolving a dispute that arose in the context of EU law and will often apply international law as a means of applying EU law, unquote. However, all courts, apart from the ICJ, which potentially has unlimited subject matter jurisdiction, apply international law in a very specific legal context. For instance, the European Court of Human Rights' task is to primarily interpret and apply the European Convention on Human Rights, something that has not prevented it from issuing hundreds of judgments that contain sections of relevant international law. More fundamentally, the CJEU's jurisprudence does not bear out the proposition that the CJEU is much more open towards international law when it functions in an international court mode. The contrast in the court's line of argumentation in Britain and Anastasiou on the one hand and Psygo on the other illustrates this point well. So in Britain and Anastasiou, the court stayed away from the international law aspects of occupation present in the case. By way of contrast in Psygo, the court characterized Israel's presence in the Palestinian territories as occupation and condemned its settlement policy as being inconsistent with international law. So for this reason, I argue that we should do away with the distinctions of openness, hostility, or domestic versus international court and adopt a highly contextualized approach, focusing on the actual circumstances, issues under consideration, and normative and interpretive choices faced by the CJEU in a given case. Turning now to the issue of interpretability of customary international law. There is evidence to support the proposition, which is central to the TRICI-Law project, that the court does actually engage in the interpretation of customary international law rules applicable in a given case, instead of merely ascertaining the two elements. However, two important caveats need to be inserted here. First, interpretive engagement with customary international law is much more evident in the Advocate General's opinions rather than in the text of the court's judgments. In this context, the court tends merely to refer to the Advocate General's findings in support of the meaning, scope, and effects ascribed to a particular rule. Secondly, even in Advocate General's opinions, such engagement seems to be implicit. In other words, although several opinions attest to the fact that the Advocate Generals engage in the distinct intellectual operation of clarifying the meaning of pre-existing customary norms, this is not clearly or expressly articulated. Some case law that confirms this. The Mahamte case concerned the jurisdictional immunities of states in the context of an unfair dismissal claim brought before German courts by a driver employed by the Algerian embassy. In his opinion, Advocate General Mengozi took note of the uncertainty surrounding the rules on state immunity under public international law and confirmed that the rule of relative immunity has replaced that of absolute immunity based on the fundamental distinction between sovereign and non-sovereign acts. The Advocate General then relied on relevant European Court of Human Rights case law as well as international instruments in order to interpret the scope of the rule of relative immunity and found that Algeria could not invoke immunity from jurisdiction. The court simply cited to the Advocate General's opinion and endorsed his interpretation. In Marina, the court was faced with the question of whether such immunity extended to private companies delegated by the flag state the task of performing classification and certification activities. The Advocate General began by highlighting that while international law has recognized the rule of relative as opposed to absolute immunity, difficulty nevertheless persists in determining the exact scope of immunity from jurisdiction, since the distinction between sovereign and non-sovereign acts remains unclear. He then went on to interpret the scope of relative immunity from the purpose of answering the question. The Advocate General relied first on the non-binding UN Convention on Jurisdictional Immunities and Their Property, which militates in favor of a presumption against the extension of state immunity to private bodies, and to EU secondary legislation, which clarifies the scope of customary law obligations arising for flag states under the UNCLOS and SOLAS conventions in the area of maritime security, and concluded that the entities in question could not claim immunity. In a similar vein to the Mahamdir judgment, the CJEU cited to the Advocate General opinion not offer any more analysis. In Western Sahara Campaign UK, the Advocate General engaged extensively with the delimitation of the meaning and scope of relevant norms, including the right to self-determination, the principle of permanent sovereignty of the natural resources, the obligation of non-recognition, as well as different IHL rules pertaining to the status of a state as an occupying power and the capacity of occupying powers to conclude agreements covering the occupied territory. Thus, the CJEU practice confirms that, far from accepting that the application of the two-element approach suffices in order to determine the content of a given rule, customary international law is interpretable, and that in its practice the court does engage in customary international law interpretation. How does the court interpret customary international law norms, i.e., what are the interpretive methods employed by the court? The court does not really engage in autonomous interpretation of the applicable rules. Rather, it tends to rely on the case law of international and sometimes domestic courts and on international written instruments purportedly codifying customary norms as a shortcut for determining the meaning, scope, and effects of customary rules. Does this diminish the quality of the court's interpretive engagement with customary international law? At face value, there is nothing inherently wrong in outsourcing the task of interpretation to other law interpreters, including the ICJ. However, this needs to be done in a careful manner and with an understanding of the broader structure and logic of international law, as well as the legal issues in each case. So in this context, the issue of misinterpretation of customary international law becomes important. Turning to misinterpretation. An important caveat needs to be inserted here. Discussing cases of misinterpretation of customary international norms implies that the CJEU actually identified and interpreted, presumably in an incorrect manner, a relevant norm. However, it is important not to lose sight of the fact that in some cases the court has framed the dispute in such a way as to avoid identifying and subsequently interpreting a relevant norm altogether. A good example is the Western Sahara saga. Here the court chose to view the legal relations between the EU, Morocco and Western Sahara exclusively through the frame of the law of self-determination, ignoring the status of the territory as one that is occupied by Morocco and the relevant obligations of non-recognition and non-assistance incumbent upon the EU on the basis of this status. In a similar vein, the framing of the dispute enabled the court to avoid pronouncing on a relevant international law issue in the Slovenia versus Croatia case. Here, Slovenia argued that Croatia's failure to comply with an arbitration award fixing the territorial boundary between them should be taken into account for the purpose of verifying the alleged breaches of EU law. The claim arguably necessitated interpreting the precise meaning and scope of the customary rule of res judicata in order to determine the legal effect of the award within the EU legal order. However, the court chose to focus on the arbitration agreement rather than on the award, as per Slovenia's claim, and concluded that the dispute fell outside its jurisdiction. Turning next to issues of misinterpretation proper. It is important to stress in this context that customary international law norms need to be interpreted in the light of the norms of the system from which they emerged, i.e. international law. In the literature, the practice of domestic courts interpreting customary norms in light of domestic instead of international law has been noted with concern, a practice which has been called as reverse consistent interpretation. The court's case law interpretation of good faith in the sense of Article 18 of the Vienna Convention as equivalent to the EU general principle of legitimate expectations may be seen as an instance of reverse consistent interpretation. There are further instances of misinterpretation. Two contextual factors are important here, namely the political sensitivity of the question at bar and the determining complexity of the norm under interpretation. The Western Sahara saga offers a number of examples of misinterpretation of customary norms, arguably on grounds of political expediency. In Front Polisario 1 and in Western Sahara Campaign UK, the court misinterpreted Article 31 of the Vienna Convention in order to support the finding that the relevant agreements did not include Western Sahara. In both judgments, the court relied exclusively on Article 31(3)c of the Vienna Convention for the purpose of interpreting the territorial scope of the agreements and did not engage at all with the other means of interpretation listed in 31, and more particularly with the subsequent practice of the parties, which arguably showed that the agreements did in fact cover Western Sahara. This, of course, goes against the crucible approach intended by the ILC and employed in international judicial practice. In the relevant judgments, the court also arguably misinterpreted Article 29 of the Vienna Convention and the Pacta Tetis rule. The complexity and or indeterminacy of the customary international law norm invoked may also contribute to incorrect interpretation. In Venezuela versus Council, the court was faced with the question of whether third states have legal standing to challenge restrictive measures on the basis of Article 263, paragraph 4 TFEU. Advocate General Hogan argued that the international law principle of comity should inform the interpretation of what constitutes a legal person for the purposes of the provision. However, the argument made by the Advocate General is not very convincing, given that there is no customary rule requiring one state to allow another state to bring suit in its courts. Rather, comity is a domestic law doctrine that has been mainly employed by US courts. A more recent example where the complexity of a rule had, at least indirectly, an impact on the court's interpretation and application of a customary rule was the Spain versus Commission case, where the court found that, notwithstanding the EU's non-recognition of Kosovo as a state, Kosovo could participate in an EU agency as a third country, within the meaning of EU secondary law. The CJEU made a reference to the ICJ's advisory opinion on Kosovo in order to support the proposition that dealing with a territorial entity as a third country under EU law does not infringe international law. However, the CJEU was wrong to assume that the ICJ's advisory opinion answered the broader question of the legality of Kosovo's unilateral secession from Serbia. The ICJ merely gave an affirmative answer to the much narrower question of the accordance of Kosovo's unilateral declaration of independence with international law, without touching upon questions of statehood or recognition. Since a declaration of independence in and of itself does not create a state or a new legal situation, it may be considered as a legally neutral act. So in this light, the reliance on the ICJ's dictum was rather misplaced. So to sum up, this discussion has hopefully has supported the main premises of the TRICI-Law project, namely that customary international norms can be and are interpreted by courts. Hopefully I've shown that in its practice, the CJEU engages in customary international law interpretation, even though it refrains from using the term explicitly, and proof of such engagement can be found in Advocate General's opinions rather than in the text of the judgments themselves. Overall, in future cases, the CJEU may wish to be more explicit regarding its interpretive engagement with customary international law. Engaging cautiously and explicitly with this task could also enhance the methodological quality of the court's reasoning. Explicit engagement with customary international law interpretation could assist the court to take into account the broader international law context of the dispute and thus to improve its reasoning on the basis of international law. Thank you.
Thank you very much, Dr. Kassoti, and thank you for all three speakers for keeping the time so well. So we have now some time. Our colleague Nina Mileva has the microphone for all of you who want to ask questions. So please feel free to do it. And also we have those people who are joining online. Please also feel free to ask questions in the chat to any of our speakers. Yeah.
Hi, Arek Navasartian, PhD researcher at the ULB in Brussels. Thank you for three very, very interesting presentations. International law is not something I engage with very often. I try to stay within the EU framework. And so I had a question to Dr. Odermatt, and maybe Dr. Kassoti can join in as well, because she touched upon it briefly. At one point you said, I feel like the underlying idea in your presentation was that the EU most often anchors its reasoning in its own constitutional framework, rather than relying on international law. And I was wondering whether you feel that that is an expression of the autonomy of EU law and a sort of adversary stance, or is it the expression of the fact that the treaties itself provide that the EU must act in conformity with international law, and then there is this sort of comfortability of the court to say, well, in any case, EU law is in conformity with international law, and thus I can anchor my reasoning in EU law. And I feel like that is also maybe something that Eva touched upon with the consistent interpretation and the equivalence of equivalence between, air quotes, of Article 18 of the VCLT and then the EU principle of transparency, I think, and legitimacy. Thank you.
If there are no other questions from the audience. Oh, there we go. Okay.
Yeah, hello, Alina, my name. Thanks for your presentations, very insightful for me too. Just to follow up, it's a question for Eva Kassoti as well. On the question of misinterpretation, I would be very interested if the misbalancing of rules of international law is also part of the definition of misinterpretation, the lack of balance of different rules to be considered in the course of interpretation. Is that also part of that definition of misinterpretation, or a different endeavor outside of interpretation?
Hi, I'm not sure. Yeah, okay, works. Hi, well, you all know me. I'm Teresa. Thanks so much for the presentations. They were really detailed. My question is actually for all three of you, perhaps a bit more for Jed and Eva. So you discussed quite at length how the court approaches international law, customary international law. The question is more, what kind of hypothetical scenario would you envisage where the court would actually go in detail on the customary law analysis or on its own interpretation of rules of international law? So I buy the argument, picking up on what Michael Wood said at the ILC, that the court's case law will be relevant for the identification or formation, expression, development of customary international law if the court actually engages in a customary law analysis. But how do you see actually the risks of the court doing so? So, because so far, based on the analysis that you have done quite in a detailed manner and other scholars, the court does not necessarily excel on its interpretation of customary international law, perhaps because it fails to engage with it, perhaps because it shies on its own mandate and relies primarily on the EU's constitutional framework, as it was said here today. Don't you think that we would have perhaps more troubles if the court would become, as one of you have actually said in their own work, this international court? Should it? What would be the risk? And yeah, that would be, I guess, food for thought. Thanks.
Thanks, Nina. Just to follow up on Teresa's question, perhaps very, very much linked, and perhaps also to the research that Jed is engaging with, but also that Fernando, on the basis of the book, already did. The image seems to be that in the end, the court is very friendly towards international law and international customary law, but somehow sort of translates it to make it work for the European Union, even mistranslates it in certain circumstances. So the obvious question at the end of the day would then be if there's any very concrete points where you feel that the European Union did actually make a different interpretation and in that sense contributed to the further development of customary law. If you look at the literature, one of the arguments sometimes seems to be that only the very existence of the European Union as an entity somewhere between states and international organizations in itself seems to be the contribution. For instance, in the area of diplomatic law, also to link this to EU Diplo, where we see that the international diplomatic law has accepted a non-state entity to participate and have ambassadors, have embassies, between quotes, and things like that. So that would be perhaps an obvious example, but I'm sure you may have other ones.
Thank you very much for all three very interesting presentations. My questions/comments are for all three and tied to a lot of the questions already addressed, so maybe there's quite a significant overlap there. The first one is if you could, and this is just essentially making a hypothesis on why potentially we see more engagement by the AGs compared to the court. Yes, I understand one of the reasons is, of course, you want to be more territorial, but then is there a particular reason why the AGs are a little bit more open to engaging with international law rather than, holding the line of focusing more on EU law? And the second one would be more of a kind of connecting also with the EU Diplo project, whether this kind of focusing more on EU law and doing this based on essentially protecting our autonomy, how this would then translate with playing with others. So essentially when you're trying to discuss issues that essentially other states or other organizations might be involved, the whole discussion about investment and so on. So whether more engagement with international law might make some of those interpretations a little bit more palatable, or the proposals by the EU more palatable to other international actors. Thank you again.
They're also online?
Yeah, I think there are some questions online. 2 of them or no? No, okay.
Do you not see one pop up?
Yes, there's a question from me, from Sarah.
Yes, please.
Yes, I put it in the chat box, but I could actually repeat it for the audience. It's a question for Eva. I would like to know what is your view on the principle of consistency, which is embodied in Article 21, paragraph 3 of the TEU. My question is on this. Do you think that the Court of Justice could more heavily rely on the principle of consistency in order to ensure that it doesn't misinterpret customary international law? In other words, do you think that there are legal instruments available in the treaty to avoid any misinterpretation of customary international law or not? Thank you.
Thank you for your question. Do we have any other questions? No. Oh, we have a question here. Yeah.
Thanks, Justin Lindenbaum from here, basically. I have a question to all three speakers. you all focused pretty much on the CJEU. And I was wondering if perhaps there is a case to be made that the CJEU should not engage actively as much with customary international law as opposed to the other institutions of the European Union, especially at a more political level, or whether you think that all institutions, including the CJEU, equally should engage as much with CIL. Thanks.
That's it? No more questions? All right, we have around roughly, I think, 15 minutes. So please, who would like to take the floor? Shall we go from this?
I think because there were some specific questions to Eva and Jed, so I think that they should speak first, maybe?
Yeah.
Reverse speaking order?
Yeah, let's do it. Yeah.
Thank you. No, the first one, I think, was about Article 3.5 and well, we've also written an article with Ramses on the normative effect of 3.5, but I'm not sure how 3.5 is, in a way, it has to do with the identity, with the narrative of the obligation to comply with international law comes from us and not from outside. And to that extent, it is relevant, but it has to do more with the narrative rather than with the application of international law in a given case. So I'm not sure how this would fit in a given case. I think it has to do more with the story that the EU is saying rather than. But I don't know, Jed, whether you had a different take on it.
About the friendliness of
Article 3.5.
I can address that when I have my
There was another one on misinterpretation, and I took the definition of the TRICI-Law project where misinterpretation has been properly in a stricto sensu interpreted. But what I merely said is that there is a blind spot in the debate, and the blind spot is the framing of a dispute. Because if you just focus on issues of misinterpretation, you may lose sight of the fact that a dispute has been framed in such a way as to avoid pronouncing on international law altogether. I'm not saying that we should open up the definition, but it's something that we should be cognizant of. Panos, that was a really good question. Yeah. Surprisingly, like, I know. And I was like, why? I don't know. I think they're offering them a more international law-friendly way out. The court sometimes, for example, Advocate General Hogan, where he made what I call a blunder in international law with a committee, the court did not address that at all. So they decided to stay away. They have much more extensive reasoning on, but it's a good question. I don't know. I think they're giving them more options. Yeah. And Sarah's questions on consistency on the basis of Article 21, I'm not sure how this would help issues of, I mean, there is Article 21 talks about consistency in EU external relations, but I'm not sure how this would help the court to avoid misapplication because I talked about the contextual factors, and I believe that the political complexity of a case and the complexity of the rule itself affect perhaps questions of interpretation. I'm not sure that consistency would be helpful in that respect. I don't see how it would be helpful. Perhaps something to consider, and I've not written it in the paper, is the expertise of the judges themselves. So now in the European Court of Human Rights, it is a prerequisite to have some public international law knowledge, which is not the case for, I believe, CJEU judges.
I'm not sure if I'm going to be able to take every question individually. I've got some notes that I think cover the topics covered. On the issue of anchoring its reasoning in the framework of the EU law, yes, I agree with that. That's what it's doing. But I also agree that I mean, you were talking about context as well. There are a lot of things we need to take into account to give that context. One of them, when I talk about this distinction between international and domestic role of the court, I understand that it's not always clear-cut which role, but that is part of the context of, is it using customary international law because an applicant has come to challenge directly the validity of an EU law act, and then in those situations may be a little bit more defensive to say, hey, you're actually challenging the validity of EU law based on this airy-fairy customary thing that exists out there rather than our legitimate treaties and protection of human rights and so on. And then things like, when you talk about context, you know, is it in the role of a request for a preliminary reference, or is it an action of an annulment, or, you know, these kind of things will also affect the kind of engagement with customary international law. Or Panos's question about, is it the Advocate General, where usually there is a tendency to go into a detail on most issues, and probably will go into detail on customary international law issues. It brings me to the example I think is illustrative of this, is the Whiteman case about the exiting the European Union. When you look at the Advocate General opinion, which goes into the law of treaties and leaving treaties and so on in international law, and then you compare that to what the Court of Justice did, which doesn't talk about international law except when it says this is confirmed by the Vienna Convention. So a total different approach of the Advocate General on the court, and that's also an example of that moving the entire argument to EU law ground to say we don't really need international law to even discuss this question. And I'm a bit agnostic on whether this is a good thing or not, but what I do think is maybe troubling, or this is presented by people in the court. I've seen speeches and read articles by the president of the court that says we're so open to international law because of the Whiteman decision, where we mentioned the Vienna Convention on the law of treaties, but only mentioned it and doesn't engage. And that's not friendly towards international law, but it allows it to kind of give that presentation. And I've argued the same thing when it comes to other cases, the Front Polisario and so on, where it's talking about international law, but it's misinterpreted, or kind of, you know, changing the question or modifying the question to give that impression. So yeah, it also depends on things like the procedural, the procedure. Justin, there was a good question as well. I think today we're focusing on the court just because that was the idea of the panel, right? But we're also thinking about how does public international law, is it dealt with by others in the institutions, legal services and the Commission and Council. These are dealing with public international law issues all the time when they're addressing things to do with fisheries or, I don't know, the war in Ukraine and things. Are looking at the status of customary international law. We don't have as many documents to kind of, we like documents and reading things, and maybe we'll always focus on the court because then we can do things like analyze references and things like this. But I definitely agree. We look at the role of EU and customary international law, we have to cast the net further than just looking what its court says. Has the Court of Justice actually done something which has influenced international law, developed international law? We can maybe see some bits and pieces here where other bodies have referred to it, but generally I don't think it happens that regularly. Because of that specific context, other interpreting bodies are probably going to say, well, this is the EU looking at customary international law, it's not as relevant. And when I had actually a project with Ramses, when we looked at the cases in context in EU law, in external relations law, I looked at how other courts and articles and books had looked at RACA years later, what influence that it had. And you look at things like the commentary on the law of treaties that mention it in a footnote and then say something like, but this was in the context of the EU, so it doesn't really... It's a one example of rebus extantibus being mentioned, but it's not relevant to us because of that specific... So it's almost a reverse case of influence to say, this exists, but it's not that relevant. I haven't gone through everyone's question individually, but I think those kind of comments touch upon most of the issues raised in the questions. So.
In some ways, I think the discussion has got me thinking about what expectations should we have to begin with about the Court of Justice's role in identifying, interpreting, and applying custom? Because as Jed noted at the beginning of his presentation, when he was framing the questions that he has been looking at, the first question is when custom becomes relevant in a case before the Court of Justice, and there has got to be some sort of European law foothold there. But it's not as if there will be loads of situations in which an individual or a member state would be complaining about a direct violation by the European Union of a customary obligation. So it may be the case that even though the courts can do better when it comes to reasoning, the courts could be a good friend here and elaborate on methodologies and its own understanding of the international legal system. That is not its main job anyway, and so we should just adjust our expectations. And that kind of brings me to Ramses's question from before. The court's direct contribution to placing the EU in the international legal order is not necessarily very expressive, is it? It is really the action of the organization, qua organization, and especially through the Commission, external relations that will really make a difference. And of course, like I'm not discounting the other political organs that will be deciding when the EU will be concluding certain treaties and doing certain things. But here perhaps we go back to that old model that we get from states where it is ultimately the Foreign Office that makes all the difference in conjunction with, of course, the seat of government. And then courts will play a role sometimes, will contribute to a few things, but ultimately will not make the biggest difference. Except for the fact, I would say, that is the one distinction I would highlight, that I think the CJEU has been so instrumental in creating this legal image of the EU as its own thing. And it has been so instrumental in articulating those principles that are now, of course, parts of primary EU law, supremacy, autonomy, direct effect, all of that. And it has perhaps displayed the sense that the project of EU law takes precedence, always. And that if international law has to be thrown under the bus for that, so be it. It's just the price that we have to pay, and that's fine by us. I think it was Eva who mentioned the sociological aspects of how those judges are selected, and I suspect that if we start looking at different international courts, we will see how difficult it is sometimes to get that nice balance of expertise that will allow a court to give judgments that will satisfy the internal constituency and the external constituency at the same time. With the ICC, there is a whole perennial criminal versus international law discussion, and they never seem to get it right ever. With the ECJ, just the way that judgments are written and how light-touched they are when it comes to reasoning and how laconic they are, I think that it isn't conducive really to the kind of engagement that we might have expected. Now, just a couple of very quick points. I was thinking about Panos' question about the Advocate Generals, and it occurred to me whether another question to be asked, and I have no idea whether that's a good question to begin with, I'll just throw it at Eva and Jed, is whether there is a distinction between the General Court and the Court of Justice when it comes to engagement with custom or those questions of international law. And I'm thinking a lot about CADI, of course, but also if you think about Front Polisario, the General Court was not satisfied with engagement by the political organs of the EU with the question of custom, and then annulled the EU regulation on that basis, even though, of course, it did not really take much of a position about whether the rules were kosher or not. And then the Court of Justice said, no. Actually, we don't need to go that far. We can interpret things in such a way in which everything becomes compatible, so let's move on. But in CADI, of course, the General Court, or the Courts of First Instance that it was then known, was engaging with the whole use Kogan's question, which the Courts of Justice later said, no, we don't need to do that. It's not our role, it's not our purpose. And I just wonder whether there is something to be found in this comparison as well. Just a very, very final point to the question of the political organs and how they use custom or not. I know I have been plugging this a little bit too much, but there is a chapter in this volume, and that's by Carmen Capdevila, where she turns to the political organs and does some research to the best of her ability, because as Jed said, it's very difficult sometimes to find the documents that will give you this data about how the political organs of the EU have been referring to custom. And, she says, ultimately, you see references to custom that tend to be self-serving, so it's whenever it is helping a political organ to maintain or support a point that they are making. The references tend to be very perfunctory, so not really engaging much with the elements of custom or the methodology of custom or the fine-tunes of the content or interpretation of the customary rule. But that's more or less that, and she speculates a little bit and comes to the intuition that perhaps what we see from the political organs of the EU is more or less what we see from the governments of states when they raise customary issues outside the realm of judicial or arbitral dispute settlement, when they are just making points in diplomatic exchanges. They use a law as much as they can, but they, of course, are not as rigorous or as interested in the details as when you really get the lawyers to do this in a bit of a focused dispute settlement context.
Thank you. And on this point, we're going to go into the lunch break, but not before we give another round of applause to our speakers.